time.
Oh, there we go. Thank you. Well, in the interest of time, I will speed talk. So for those of you who are recording this, you can slow it down later. My name is John Maldijian. I'm an intellectual property attorney, and I guess we'll save the best for last. I hope I don't disappoint you. And I want to give my apologies to Dr. Tinker in advance. Please do not shoot the messenger.
We're not going to kick him out, but we still like them.
As Dr. Tinker mentioned, and I'm actually impressed by your history lesson, intellectual property in the United States does come from England. It dealt with the feudal system at the time. That is why in the United States, if you want to use the long version, it's letters patent. It is effectively very much related to real property. So a lot of analogies are made in the field of intellectual property to real property, and it's effectively the same thing. If you give us your information that is not yet public domain, we will give you a limited monopoly in exchange for a quid pro quo to give that back to the public in now 20 years from data filing. So a little bit of who I am. John Maldijian, Maldijian & Fallon. I did get a degree from Rutgers University in electrical engineering, and I guess I was invited here today to speak in accounting because all three siblings of mine went to accounting, and one is a CPA, my wife is a CPA, and she audited for Grant Thornton. So thank you for having me. Other than that, I have no idea what you guys are all talking about today. And maybe that's a good thing, and that's why Nicholas invited me. So hopefully I can tell you a little bit about intellectual property without being skewed towards auditing and continuous auditing. So what is intellectual property? In the abstract, it's protectable and enforceable rights that can be exploited, both offensively and defensively. Offensively, as you receive a patent, you can prevent others from making, using, or selling, offering for sale, or importing into the United States that which is claimed. And so offensively, you can stop people from doing things. Defensively, you can use it as, if you have a bunch of patents, you can use it as an arsenal, a defense. If someone were to come to your company and say that you're infringing, you put up your group of patents and you let them know that, if you want to throw the first shot across the bow, how about you look at our patents and we cross-pollinate and cross-license and avoid any type of litigation. It also adds value to an entity's bottom line, and to Dr. Tinker's point, it sometimes takes away from the free and open discussion and use of things such as medical devices, methods of having operations. There are various things that if you look at an economic model, sometimes patents can be a detriment. But again, don't shoot the messenger. I'm here to just tell you what it is. So intellectual property rights, what are the types? I like to break them into little buckets. Patents is the one we're going to talk about today. But if you notice, we also have trademarks. We also have trademarks, which are things that protect names, slogans, logos, etc., that will identify a source of goods or services. So McDonald's for restaurant services, we all know when you go to McDonald's, you're going to get a particular type of French fry, or you're going to get a particular, and you'll know the temperature if that system didn't work, it worked out. Copyrights protect creative works of authorship. So textbooks, one of the reasons they are expensive is the copyright owner and the publisher want to gain some protection in having to expend the cost of publishing them. But with the internet, things are changing. Trade secrets, I like to say trade secrets are the genesis of patents. You can have a trade secret, and it's a protectable, confidential, and proprietary information that if you don't apply for a patent application, that basically is the start of your process. In other words, you can come up with an idea, an invention, and just keep it confidential. The Coca-Cola formula is a clear example of that. It's still protected to this day and recognized by the courts and the systems that it's a protectable trade secret. So you don't have to go the patent route. However, if you can reverse engineer something in the marketplace, your trade secret goes away. So that is why a lot of people opt for patents if they want to protect an idea. So, what is patentable? I guess, unfortunately, for some folks here, anything under the sun made by man is patentable. This comes from a Supreme Court case in 1980, where the Supreme Court was considering whether or not a live animal, a biological bacteria that ate oil, was protectable, and they found that it was. But it may not be for all business methods, but we'll have to stay tuned to the end of the lecture and perhaps miss your taxi. Okay, patents, what types? We have utility patents. That's what we're talking about today. Utility patents are the ones that most folks know about. That's where business methods fall in. I would assume that everything we're talking about today would be considered a business method patent. Design patents protect the ornamental design or aspect of a useful article. So that would be the shape of something. That's not going to be talked about here. And plant patents, believe it or not, they give out patents for people who can asexually reproduce plants.
Yeah.
Yes?
I don't want to be rude, but a lot of people have to leave it.
Absolutely.
And we wanted to draw on your competency to help us to discuss what it means to us, researchers and practitioners of continuous auditing, that there is a continuous auditing pattern.
Mm-hmm.
So maybe you could just kind of go to the key slide.
Absolutely.
And have a little discussion, which is what we're all eager to.
Beautiful. And anyone wants to see my slides, they're obviously on the internet. You can see them. But I got a little jealous. I wanted to put some formulas in here, so I did. But really, this was something that, how do you protect innovation in academia? It is, it's pretty much the same way you do in industry, but what is an invention? An invention is conception, reduction of practice. It can actually be an actual reduction of practice or a constructive reduction of practice, something important for folks here. When you're coming up with an idea, a concept, as long as you have a concrete concept in your mind, you can write it down. That's when you go and seek out a patent if you so choose to take that route. You do not have to build a prototype. You do not have to build it in software. You can actually have the patent application become the reduction of practice constructively. We talk about inventorship. You can read that.
I think the thing most of us are really interested in
Yes.
is what it is that these guys have patented and how that works.
Okay, what did they patent? I didn't want to get into their particular patents because as an attorney I didn't want to give opinions as to what they patented.
But I personally don't even have a clue what it is they patented.
Okay.
To be honest, and I'm really interested to find out. I think most of us probably
Okay,
are.
very good. Well, this will lead to it. I will tell you what is patentable in the business method area. And then I could open it up for questions and answer it that way. But effectively, this is a little riddle of whether or not you can patent a data processing system for hub and spoke financial services, similar to auditing. It's in the business area. The spokes and hubs are mutual funds. This is an actual patent that issued. You get a patent on that. But was it a valid patent? 1998, the court decided it was. And you can read through why that is. But here's the key to business method patents and what these folks invented in the abstract, which is what I can go into in detail. Whether or not, the question was back then, whether or not it's machine or transformation. Okay, a machine effectively is a computer, some type of calculating device. It can't just be an abstract idea. The court decided if it's a machine or it transforms something, information, data, into a useful, tangible result, that, believe it or not, is the criteria of whether or not you can get a patent on a business method in the abstract. Okay, fast forward to 2010, which a decision was just made by the United States Supreme Court on these folks. What happens if you have a method for managing the consumption risk cost of a commodity sold by a commodity provider at a fixed price? Again, similar to what you folks are doing here, but not the exact same thing. The question is that patentable? Well, unfortunately, in this particular case, it was not. Why it was not? Because it was an abstract idea the court found. Okay, so what happens again? Generally speaking, how did these folks get their patent? It's likely that their patent had a machine or transformation test, a machine or transformation in it, and it wasn't an abstract idea. Now, I took a look at the patent. Again, I can't give out illegal advice. I took a look at the patent. The patent relates to continuous auditing. Both patents, in general terms. If you want to find out what exactly it is that they patented that I guess would prevent you from practicing this, you would have to look to the claims. The claims are at the very end of the patent. It actually starts with what is claimed is or what I have claimed is. And you look, and each and every element of those claims is exactly what the Patent and Trademark Office granted to these folks in terms of what they can or cannot practice or prevent others from practicing. Question?
I'm actually looking at the patent right now.
Okay.
And I'm looking at the claims section that runs, I guess, from 1 to... It's got several things. The first thing is basically it describes a computer. It says a method comprising providing a processor, providing a memory interoperably coupled with the processor and having computer software code, and C, using the processor and the memory, and this is basically describing a computer, to do at least one of the following. And the first thing it describes is dividing a non-sample total population of financial transactions into a plurality of financial statement categories. That sounds to me like that's taking a set of transactions and developing a trial balance. And if you've got a computer and you're using it to download a set of transactions and develop a trial balance, that seems to me to be covered by the patent, and that doesn't seem to make a lot of sense. So I'm really curious as to how this thing works, because it looks like they've just patented auditing.
Correct. Again,
I hope not.
What? I actually had a couple slides that I deleted, which was have no fear of patents. Here's the thing. It's obviously a concern that when a patent is issued to someone in a field that appears to be as broad as possible and possibly could stop all of us here in the room from practicing what you've done for the last 20 years or so, that's daunting. And I understand and appreciate that. Now, the question is, the only thing I can tell you is the process in which they receive their patent in general terms is a process that is not necessarily 100% foolproof. And what I mean by that is the process, as Dr. Raj pointed out, it took us 6 years for them to receive their patents. I'm not sure how long it took you folks.
7.
7 years, okay. In that process, it's not a perfect system. Patent examiners at the Patent and Trademark Office examine these patent applications by looking at what existed already out there in the prior art, okay? Now, what existed already out there in the prior art is what the examiners have in front of them. They have a limited database of patents and patent applications and possibly some publications that they know about that they can search in their system to see whether or not these folks have something that's new and non-obvious. So the process continued that for 7 years, they went back and forth with the patent examiners presenting these folks with, hey, we don't think your thing's patentable because it already existed out there. Here's some patents to prove it. What do you think? The patent examiners went back, patent attorneys went back along with these folks and argued as to why their particular claims are still patentable. In other words, they're still novel and non-obvious over what's out there in the prior art. I'm not here to judge or give an opinion of counsel as to whether or not I agree with the patent examiner's decision on that. I will tell you that half of my job as a patent attorney is to get people patents. The other half is to knock those patents out of the water. And here's why. Again, it's the economic model. The patent examiner has 17 and a half hours to decide whether or not they're going to give a limited monopoly to some folks that could shut down an industry. 17 and a half hours. And in those 17 and a half hours, they have to do a search. They have to understand the application. They have to find it. They have to send an office action rejecting the claims at first, which I'm sure you received several rejections. They have to go back and forth. At that point, they run out of what they call disposal points. I'm telling you the reality here, folks. I'm sorry to tell you, but it's not a perfect system. Here's the problem. When that patent issues, or it's a problem or a good thing for some folks who get the patents, when that patent issues, it's presumed valid. In order to overcome that, outside of the patent office, now you're out of the administrative body and you're into the law, you're into the legal system, you have to overcome the validity of that patent by clear and convincing evidence, which is more than a preponderance of the evidence. In other words, you have to convince the court by about 75% belief that those patent claims are invalid. So it's a very tough standard to overcome. So when patents do issue, it's a concern. There have only been rare occasions where the patent office has actually retracted their agreement to allow patents to issue. There are processes to do that. The processes are requesting for reexaminations or reissuance. You only can do that if, for instance, there is new prior art that you might find out in the industry that was not in front of the examiner. And if it wasn't in front of the examiner, the Patent and Trademark Office is admitting, listen, we're the government, you're paying us X amount of dollars to do this, it's not enough. If the industry really wants to fight this, they can, but you're going to have to show us proof that we didn't have this in front of us beforehand. Is that answering some of your questions?
Well, it says a whole lot about the patent office as well.
Well, the reason...
No, what I still don't understand is what it is has been actually patented.
What exactly did they patent? You know, I purposely did not want to analyze that. I apologize. But if I did that, I don't think it would be fair to these folks. Because as a patent attorney, I could give you my opinion as to what I think they patented. But I will tell you, look at the claims. I will tell you in general terms, not directed to their patent only. In general, if you look at the claims, it's a roadmap. It's the elements of what they have gotten as their fences. In other words, they cannot... would not be able to interpret the claims of their patent as owning continuous auditing through a computer now. They just can't. If you look at their patent itself, it has quite a few patent references and publications cited against them. Okay? And so, if I may, I will tell you, generally speaking, how to go through the analysis of either a non-infringement or invalidity. But basically, you look at all the prior art patents, and you look to see what they claimed, and then you compare it to the claims of their patents, and you see what exactly did they get. You can also pull down the file wrapper or the prosecution history of the patent, and you can see exactly what arguments they had to make to overcome the prior art. And that will show you how their claims have been limited to only claiming what the Patent Office believed to be new and non-obvious intellectual property.